I call the whistle all.
Tēnā koe te māngai o te whare. It's my pleasure as a member of the Justice and Electoral Select Committee to speak on this. The Judicature Modernisation Bill that has been split into actually 23 bills, and I'll speak to one primarily soon. But I just wanted to acknowledge the work of the Law Commission and their report, review of the Judicature Act 1908 towards a new Courts Act. And so we really should acknowledge that piece of work that they undertook actually has helped result in this bill before the House. I'd also like to thank the officials and also the Select Committee and previous Select Committees. I actually have had no active involvement in submissions and the process that the Select Committee went through to get to this point. But now as a member of that Select Committee, I get to speak on this, the third reading. I just wanted to note a few things in terms of what this bill will enable, and it will provide, for example, the district courts to deal with civil cases up to $350,000 from the $200,000. So we are expanding the jurisdiction and I guess the cases that district court can hear. It's also improving flexibility for the court to limit vexatious proceedings, and I'm sure there'll be members of the court system who'll be happy to hear that. And it also enables specialist panels of judges to be assigned to hear particular types of cases in the High Court. And it was really interesting kind of finding out where that came from, and it was Issues Paper 29 that the Law Commission put out, and it was actually replicating a system that currently operates in Australian courts. And then when I was looking at, so what types of specialist skills or specialist panels are we looking at, and the example that's given a lot in the literature that I've read is about commercial specialisation, and maybe my colleague Claire Curran will talk about that. And the rationale was actually about providing access to justice for the commercial community. So I found that really an interesting rationale. But I really want to spend most of my contribution on the Te Ture Whenua Māori Amendment Bill. And that was because during the committee stage debate, I did move a supplementary order paper. It was supplementary order paper 216 to ensure that reform of Section 7 of the Te Ture Whenua Act was really clear that the Minister of Māori Development appoints the Māori Land Court judges. And that was really to acknowledge the taonga that our whenua is. So Māori land is so special, and Māori and the connection and relationship between the whenua, the landowners, the Māori Land Court and the Minister for Māori Development, from my perspective, and I think the perspective of many of us across the House, was that we should actually make it explicit in the legislation. Because what is made explicit in the legislation actually is that that's the responsibility of the Attorney-General. And so we amended the legislation to now empower the Attorney-General to seek expressions of interest, to appoint judges for the Māori Land Court. But there's a really interesting clause in this Te Ture Whenua Māori Amendment Bill 7, which says, if the Attorney-General is not for the time being responsible for recommending the appointment of judges of the court, he or she must publish information explaining the responsible minister's process for doing the things referred to in subsection 6, which is his responsibility and autonomy and responsibility in appointing and nominate or going out to the public to enable people who are suitably qualified to nominate for any vacancies. And I do want to highlight, as my colleague Matiria Ture did, the fact that the Māori Party MPs did not support that the Minister of Māori Development appoints the Māori Land Court judges. So people out there will think that's really strange and bizarre, and why didn't the Māori Party and the Minister himself support the fact that he should be the one, as the Minister for Māori Development, to appoint the Māori Land Court judges. Now, I've got no idea why they didn't think it was an important thing to do. And what we do know, and I'd like to acknowledge my colleague Mika Whaitere for highlighting the fact, is that there's a lot of changes in the Māori Land Court. And there are a lot of redundancies happening. I presume For example, that means that the Minister of Māori Development has had none or will have no responsibilities in that area. And obviously, the staff that are employed by the Māori Land Court are there to support the Māori Land Court judges. So it's just an incredibly curious thing for the Māori Party to vote against. One of the other areas that I was particularly passionate about was actually about diversity and inclusion of the judiciary. And the Law Commission, in fact, said to the Select Committee in their submission and made it really clear that they thought judges should be appointed based on gender, cultural and ethnic diversity. So they were really clear that having a representative judiciary was going to make access to justice a lot easier. And so for them, having social awareness and sensitivities to diverse communities and tikanga Māori was a way of providing criteria that would enable the judiciary to reflect society. And I think there's a lot of discussions happening at the moment about issues such as structural bias. The old-fashioned term is institutional racism. And maybe one of the best ways to address institutional racism actually would be to ensure that the people who are making the decisions when people come before the courts actually had the social awareness and sensitivity to be able to understand some of the circumstances, some of the life history of people coming before the courts to hopefully make it, if it is their first time and their first offence, the last time that the court had to deal with any issues. And so that particular supplementary order paper was not supported by the government, but it also wasn't supported by New Zealand First, so I have to acknowledge that my colleague Dennis O'Rourke didn't think that was a good strategy, I suppose, in making sure that there was diversity and inclusion within the judiciary. But I did highlight in the committee stage debate that the police have committed to diversity and inclusion and actually have a 50-50 aspiration for women in the police force. Now, some would have thought that that was a lot harder to achieve, but I think putting it on the table and continuing to have the discussion about it means that actually it's out there. We have to think about it. We actually have to make an active decision about whether we support initiatives such as that. And so, I was really pleased to be able to put that to the House. And in spite of it not going through, I do know that judges now do receive tikanga Māori training, for example, which is reflective of the skill set that is required in the undertaking of their particular duties. So I'm not going to prolong the debate any longer. We are supporting this piece of legislation. I want to congratulate Minister Adams. She's had a few successes lately, and I think she is incredibly diligent in the work that she does. And so I commend the bill to the House. Thank you, Mr. Speaker.